Hello, everyone. Thank you so much for joining our webinar today. We really appreciate you joining us to get a better understanding of the contracts world and legal essentials for SaaS businesses. My name is Lauren and I'm joined today by Jacqueline. She's one of the senior lawyers at LegalVision and we both work in the commercial contracts team and do a lot of work in the IT and privacy space. We were obviously expecting to be together doing this today in the office, but like most of Australia, all at home in lockdown. As you'd be aware, today we are going to be talking about the legal essentials that a SaaS company needs with a focus on your contractual needs. So what we'll do is we'll start off with the basics of what a SaaS business is, and then we'll look at how a SaaS business can incorporate contracts into their business. And then we'll go through what contractual considerations you'll need to think about when putting in place a contract. Throughout the webinar, you'll be able to submit questions. And so we encourage you to do that and we'll go through them all at the end and hopefully we can answer your questions. And we'll also at the end of the webinar have a special offer for webinar attendees from LegalVision. So to start off with, let's get Jacqueline to give us a rundown on what a SaaS is.
Absolutely, thank you, Lauren. So I think it's really important that we understand what we're talking about today. So we're talking about SaaS, or software as a service. And software as a service is a software licensing and delivery model in which software is licensed on a subscription basis and is centrally hosted and made available via the internet. In other words, you don't need to download it. I thought it might be useful to look at some popular and key examples of B2B SaaS products. Some that you're likely to be familiar with include SurveyMonkey, Slack, MailChimp, Zoom, and Salesforce. While SaaS businesses know that they need to have a contract in place, it's not always clear what type of contract you should have in place or what form that contract should take. And it's really important that you understand that as kind of the first stepping stone in the process. Lauren, did you want to talk us through the different types of contracts that you can have in this space?
Sure. So we usually call it a SaaS agreement, which is your business's main terms and conditions between you and your customers. Of course, there's many different words can be used to define this. We've got business terms and conditions, license agreement, terms of use. Essentially, they all sort of mean the same thing. It's more about what's in the actual contract as opposed to what we're calling it. So today we'll use the term SaaS agreement. When you're thinking about putting in place a contract for your business, there are different ways you can go about this. So the two that we like to talk about are online contracts and offline contracts. So an online SaaS agreement is probably something that you're quite familiar with when you sign up to a platform, for example, and you can put in your details, you can register for which tier or package of a subscription you'd like, you can put in your payment details, and then you agree by checkbox to the terms and conditions on that site. That can be really useful and effective for many businesses. It's nice and efficient. You have a good record of everyone that signed up to your terms and conditions and which version they signed up to. You don't need to faff about with the admin of filling in contracts for everyone and dealing with all of that. And so a lot of businesses prefer to do an online contract because of the ease of use, I suppose. We also have offline contracts. So these are your more traditional contract that you might think of where it's a couple of pages or in this case, maybe a lot of pages. And there's an execution block at the end where the customer and you can sign the document. Generally with these offline contracts, we'll have a table at the beginning of the agreement or the end of the agreement called a schedule. And in that schedule, we can put in the commercial details. So your details, their details, what's going to be included in your offering, the price, the payment terms, and any special conditions. This can be really helpful if you're providing more bespoke packages to clients and you want to be able to change what you're offering or give different prices to different businesses based on who they are or what they want. And so whilst we're calling this an offline contract, these days they are often accepted online as well via document execution platforms like DocuSign, which are quite helpful and good for contract management. So when you are thinking about putting in place your contracts, you really need to think about, well, how do I want my clients to sign up and how am I going to onboard them onto my SaaS? Some businesses will think about having both options. So I was speaking to a client the other day and they really wanted to have all of their terms and conditions online because it's just much easier. But they know that when big customers come along and they're offering them a lot of money or a good chunk of business, that's a bit hard to say no to. And if they wanted to negotiate the terms with them, they're happy to have their offline contract with those larger customers. Jacqueline, do you want to maybe run through now what we like to talk to our clients about when they are looking to put in place a SaaS agreement?
Yes, thanks, Lauren. So as Lauren's saying, it's really important to understand what form you want your contract to take, online, offline, or both options. But it's also important what you put in that contract as well. So you might be familiar with SaaS agreements because, as Lauren was saying, you probably signed up for SaaS products yourself. And you've probably seen those terms and conditions there. And there are a lot of examples out there, but a lot of them are US-based contracts, for example, and a lot of them are also not specific, or all of them are not specific to your business. So when we think about a SaaS agreement, we think it's really important that you have a SaaS agreement that's drafted for Australian law and that's specific to the way that your SaaS works as well. So Australian law is important because the way that liability works in Australian contracts compared to US contracts is quite different. And we're talking in terms of limitations and exclusions of liability and indemnities, but we're also talking in terms of legislative requirements. For example, in Australia, there's the Australian consumer law, and there's also the unfair contract terms regime. And then on a New South Wales level, we have substantially prejudicial terms that we need to consider as well, which is a relatively recent change. So we need to think about how these apply to your business and what obligations you have under these laws and how they impact the terms in your contract as well. So it's important that you think about how Australian laws interplay with what you're offering. And then it's also important that we talk about how your product actually works. So how are people signing up? And once they have signed up, what's the process for getting authorized users on board, for example? Is that something you're managing? Is that something that the customer needs to do themselves? What's the process for asking for support from you? And what kind of support are you offering as well? And what are your support hours? Those sorts of things tend to be quite bespoke to your business, and it's important that the contract reflects how that process works. It's also important that we talk about more legal provisions in the contract as well and how you want those to work for your business. So for example, intellectual property, there's different ways to own and license intellectual property, or data, what data is being input and how is it going to be used. Privacy, what laws apply and how are you going to comply with them, what promises are you going to make, as well as how you want to manage your risks and any service level commitments that you want to make as well. These are all things that can be done in different ways, and it's important for you to think about the commercials and understand the legal risks and have a contract that's drafted to reflect that. I think it's important that we talk about each of these things in more detail, and we will go on to do that because they really are core provisions in a SaaS agreement. I think the first one we should talk about is IP and data, because there's a really interesting interplay between the two in that they're quite similar and yet also quite different. Lauren, did you want to talk us through a little bit more around how IP and data works in a SaaS agreement?
Sure. So as Jacqueline just mentioned, IP and data are both really important concepts, and they're quite similar, but they are also quite different. And so usually we'll cover off both of these concepts. Intellectual property, that refers to creations of the mind. So in terms of your SaaS, it refers to, the underlying source code in your platform. It's going to refer to any branding you've got, the layout, the look and feel of how your software works. This is obviously where the value of your SaaS business comes into play, and it might be your most valuable asset. So it's really important that we protect that, we set out that you own that. And if you're going to give permission to people to use it, which obviously are your customers, then that should only be on certain grounds. And so we can give your clients permission to use your software, but we can put restrictions around that. So this includes things like you'll only license the software to them if your clients make payment. So if they stop making payment, you should be able to revoke that license. Or you might put in place a license where they're only allowed X amount of authorized users, or that they can't be reselling the license or reselling the software. And so in your contract, we'll like to set out that you own the IP, you're licensing it to your clients to use, and then we'll also need to think about whether or not your clients own any intellectual property that might interplay or interoperate with your business. So for example, if your clients can upload images that they own onto a platform or onto your software, then you might need permission and a license from them to use that intellectual property. You're also going to want to consider in terms of data, who owns what. So data refers to any information or data that's going to be stored by your business or inputted into your platform or perhaps generated by your SaaS product. So for example, you might be generating compliance reports or reports that can tell clients about their business's CO2 emissions or something. And so in terms of this data, we need to think about, well, who owns that? Is it the client that owns this data, or is it yourself that owns the data? And so we'll separate that out and write down who owns what and grant some licenses between the parties to use that data. So when we think about reasons you might want to use a client's data, obviously you'll use it to provide your services to them to back up your software, but you also might want to use it. A common one is for analytics purposes, where you might aggregate some data or anonymize it so that you can look at that data and then commercialize it, whether that's to create reports or to sell it, but you want that right to use that data. When your clients are inputting data into your platform, sometimes that data might be numerical, but other times it might be personal information. And so when we're thinking about personal information, then we need to start thinking about privacy as well. Jacqueline, do you want to run us through what we tend to think about in terms of privacy?
Yes, thanks, Lauren. So absolutely, when you have data, you need to think about whether any elements of that data includes personal information. So if there is information about people, so things like names or addresses or other information that might make that person reasonably identifiable, then it's going to be personal information. And we need to think about what information is being input, how is it being input, how is your business handling it, and are you using the personal information to do anything other than provide the services? We also need to think about which privacy laws apply to you. So privacy is obviously a regulated space because it's important to protect personal information. However, it's also important to understand whether you actually have any legal obligations to comply with privacy laws, and if so, which ones. In Australia, there's the Australian Privacy Act, which is the main Commonwealth piece of legislation. However, there's a threshold test to determine if you need to comply with the Privacy Act, so it won't always be relevant to your business. Other laws might apply to you as well. For example, if you're in the health space, you might have obligations under health records laws. Or if you're operating in other jurisdictions overseas, you might have obligations in other countries as well. For example, in the EU, there's the GDPR, which is one that comes up a lot for a lot of our Australian businesses. You need to understand what your obligations are at law, but even if you don't have any obligations under the Privacy Act or under foreign jurisdictions like the GDPR, your customers or clients might still expect you to sign up to comply with such laws. If they're putting in personal information about their staff, their employees, their customers, then they're going to want you to handle it in a specific way. So if your SaaS is handling personal information, it's important that you think about what commitments your customers expect from you and what commitments you're comfortable to make as well. And that's something that it's important to get legal advice on in terms of what that actually means for your business. Under Australian privacy law, it doesn't say that you need to include anything specific in your contract, so anything you do include is entirely optional. However, there are market practice things that it's standard to include, and these include limiting how you'll use the personal information. So for example, just to provide the services and to create analytics. It's also common to include a data breach clause, so what will happen in the instances of a data breach. A clause around security, so what types of security measures will you have in place? And sometimes we'll also see an overseas transfer clause. So when can you disclose overseas, and does it need to be with consent? Does it need to be to specific countries? What safeguards will you put in place? It's important to note that Australian privacy law is different to the GDPR in that respect, in that the GDPR does stipulate specific things that need to go in contracts where you're processing personal data. It also stipulates certain safeguards that need to be put in place where personal data is being transferred outside of the European Economic Area to an inadequate jurisdiction, of which Australia is considered to be one. So if you need to comply with the GDPR, it's important that you're putting in place the things that the GDPR says needs to be in your contract to make that possible and to make your customers able to contract with you. In terms of the way that that's done is if you need to put in place GDPR provisions, it's normally done via a data processing addendum or a data processing agreement. So it sits outside of the SaaS agreement itself, but it interrelates to the SaaS agreement. It's often referenced in the SaaS agreement and incorporated as part of the SaaS agreement in the drafting of the data processing agreement. Apart from putting in place contracts, it's also important to look at other privacy documentation that you need to have in place. And a key other piece of privacy documentation is your external privacy policy. And it is what it says it is. It's a policy and not a contract. So it's supposed to tell people about how your business handles personal information. And not just within your SaaS product, but also in all the other ways your business might handle information, such as when you're marketing your own product, onboarding your own customers, providing your website, etc. While privacy is a really key risk and one that we need to think about and manage, it's not the only risk. Lauren, do you want to talk about how we typically manage other risks in a SaaS agreement?
Sure. So as Jackie said, privacy is one risk, but there's plenty more risks in offering any sort of, all businesses have risks, particularly if you are providing a service and other businesses are going to be relying on your service. So issues can go wrong all the time. Perhaps your service just stops working, or it is not giving out accurate information, or businesses are relying on it and then making own internal business decisions for them. And so what we generally do in a contract is we draft a liability clause. And what we can do here is we can allocate risk between the parties. So if something goes wrong and there's some sort of issue, who is going to be responsible for it? As you can imagine, these clauses tend to be the more hotly contested clauses in a contract negotiation of a SaaS agreement. And that's just because of what's at stake here. So usually what we do is we look to exclude your liability for certain things. So we'll set out a list of reasons or issues where we don't want you to be liable for any liability. So this might include things like when something goes wrong and it's your customer's fault. We don't want you to be responsible there, or any of their authorized users, or perhaps a third party. Or it could include things like when you have any scheduled maintenance or scheduled downtime that you've told people about. Or perhaps we also want to exclude your liability for any sorts of things that are outside of your control. The other thing we'll look to exclude is your liability for consequential losses. So these are losses that stem indirectly from your provision of the services. So if someone's relying on your software for some sort of internal business decision, and then their company loses a profit, this is something that you don't want to be responsible for, and the losses could stack up quite quickly. And so it's important to exclude your liability there. The other thing we like to do in a SaaS agreement is to put a cap on your liability. So what this means is that it's basically the maximum amount that you can be liable for, or someone can sue you for under this contract. And that's quite effective in minimizing any risk you've got, because you know that there's a maximum cap there. Outside of the contract, of course, there's other things you can do to mitigate any risk that your business has. And one of the key things you should be doing is making sure you've got insurance as well. And so this is a risk mitigation tool that sits alongside your contract, and something you should be speaking to an insurance broker about which sorts of policies you should be taking out. once we draft up these liability clauses, of course, your clients might be concerned if you're not wanting to take responsibility for certain things, because obviously they want a quality service and that you will be responding to them and providing them what they're expecting. So perhaps, Jacqueline, do you want to run us through how an SLA can interplay with this?
Yes, thank you. So I think that's a good follow-on in that a service level agreement is a good tool for you to be able to use to show your clients that you can fulfill what you're promising to them. So as Lauren was saying, we want to draft the contract to limit your liability, exclude your liability where possible and where reasonable. However, we also want to make sure that your customers are confident that you're going to be able to provide the service you've told them you will provide. And a service level agreement is useful in this respect, in that it allows you to set out if you're going to say that your service will be available or have a specific uptime. And also it allows you to make commitments around support in terms of response times and resolution times. When we talk about availability or uptime, we're talking about the time that the service is accessible by the user, and it's often displayed in a percentage amount. So for example, it will be available 99.98% of the time. When we're drafting a service level agreement for availability, we want to make sure that we're drafting it so that the calculation of availability makes sense and works for your business. And we also want to make sure that we're excluding from that calculation anything that you can't control or that you have planned for. So scheduled maintenance, for example, should not form part of the availability, or where there's a force majeure event. So for example, a flood or a fire, something that you can't control that impacts the availability of the service. We also want to think about whether you're promising availability and support or just one or the other. You don't have to do both, and you can do both. In terms of support, when we talk about response times, it can be an automated response. So a response that's saying we've received your request and we're on it, for example. And that's a good way to make sure that you're meeting time commitments in that respect. When we talk about resolution, again, it's important the way that we define that in the service level agreement. So typically we want to make sure it includes a workaround in case you're not able to totally fix the problem within the agreed time frame. The times that you give can be indications to give the customer confidence, or they can be times that you commit yourself to. And if you don't meet the availability or the response time or the resolution time, you can offer to provide some form of compensation. So that might be a fee rebate or service credit, for example. And the way that those work is that you would typically have priority levels. And if you have a high priority incident, like the whole service is down and you don't fix it within the time that you've promised to fix it within, then you might offer a higher service credit, which would be in the form of, say, a 10% discount on the next month's invoice. Whereas if you have a low priority issue, like someone submits a service request, just asking if they can have some information about, how to access a certain thing on their account or something like that, that's less of a priority, and you don't meet the response time, then you might not provide any service credits in that instance. It's important that you're clear about what the different priority levels are and what the process for claiming a service credit is in the service level agreement as well. The benefit of using the service level agreement is that you're showing that you're making a commitment and you're saying this is what will happen if we don't meet that commitment. We often hope that by using a service level agreement, we can help head off disputes in that the customer knows what will happen if you don't do something in the way that you've said you'll do it. And also we typically want to try and say that any service credits or fee rebates offered in the service level agreement are the customer's sole and exclusive remedy to the extent that we're permitted to do that by law. So it gives you a lot more control of what your risk is, in that you can make commitments that you know you can meet, and you should test those to check that you're comfortable that you can meet them, and you're giving your customer something that they're happy to see on the paper as well. So a service level agreement is not something you have to have, but it's certainly something that can be useful to include in your agreement. And I think that brings us to the end of the key topics that we were going to discuss today. But we do have a cheat sheet available, which you can download from the webinar panel. So you can see an example of it on the slide there. And we also have time for questions as well. So if you haven't submitted your questions already, please feel free to submit them now. And we're going to just have a look and jump into some of those questions. So, Lauren, it looks like we've had a question come through about, do I need an NDA to protect my business? Did you want to answer that one for us?
Yeah, sure. So obviously a lot of businesses are really concerned about confidential information. That being information that's confidential to your business, other businesses don't know, the public doesn't know this information, and you want to keep it that way. You don't want other businesses, your competitors, maybe finding out about what your business plans are, or the new product you're planning to release next month or something. And so an NDA is essentially a contract which you can sign with other people or other businesses, where you're making promises to each other not to share any confidential information and to only use it for a specific purpose. And so an NDA is generally used in the context of having discussions with another business. So say, for example, you wanted to bring on board some developers, or you wanted to discuss a matter with a potential business partner, then you could enter into an NDA with them. You could say to each other that the only reason each party can use the confidential information is for the purposes of this discussion. And then should you decide to have an ongoing arrangement with them, then we can have confidentiality clauses in your other contracts with them that would supersede the NDA. And so here, if you're engaging any contractors or anyone to work for you, we can put confidentiality clauses in those contracts. Or if you, in your SaaS agreement, if you're going to perhaps be disclosing any confidential information to clients, then we can put confidentiality clauses in your SaaS agreement as well. So I would say that NDA is quite an important document in terms of protecting your confidential information, and is useful in terms of when you're having discussions with other parties. But of course, if you're engaging anyone on a long-term basis or entering into any sort of agreement with someone, then we can also put confidentiality clauses into that contract. We have also had a bunch of questions come through around privacy. So what I'm saying here is some questions around what are my obligations if I'm providing a global business. So I've got a SaaS that's operating in multiple countries. What are my privacy obligations?
Yeah, so I'm happy to take that one. Thanks, Lauren. So when you're providing a SaaS product that can be purchased globally, it is important to think about what privacy laws will apply to you in Australia, but also what privacy laws will apply to you in other countries as well. Every country has their own privacy laws, and they have their own thresholds in terms of when they will apply. But I guess a good kind of general rule that most businesses operate on is that if your product is just available online, and by virtue of being available online, people in every country can access it, then it won't necessarily need to comply with every privacy law in the world. Most privacy laws turn on a factor of some form of having a business established in that country, operating in that country, whether you actually have a company set up there or not, targeting people from that country, consumers from that country, for example. So generally the way that businesses will handle global privacy compliance is that, first of all, you would start in your home market. So for example, Australia, if your business is set up here, or you would look at a key target market that you're going to target that you think has more onerous privacy laws, for example, the EU, if you are selling into the EU and need to think about the GDPR. And you would start with one set of privacy laws. So first of all, get some advice and understand what your obligations are under those privacy laws, and also get some documentation put together to reflect those privacy laws. So a privacy policy, and perhaps also some internal documentation to guide your staff on how to handle personal information on a day-to-day basis. Then normally you would go and look at what your other key target markets are, or where you've got other establishments, and you would take the documentation and advice that you received from the first lawyer, to the lawyer in that other jurisdiction to see if there's anything different or extra that you need to be doing in that other jurisdiction to comply with their privacy laws. But I guess overall, it's kind of making a decision of whether you want to try and apply the same privacy standards to all of your customers, or whether you want to try and have a kind of segmented approach. So for example, you might say, okay, we're an Australian business, we do Australian privacy law, we have an Australian privacy policy. And then from there, you might say, okay, if you are in the EU, then we've got additional rights that apply to you and additional obligations that apply to ourselves, and you can see those in the end part of our privacy policy. If you're in California, then we have, again, different rights, different obligations that apply, and you can see those also at the end of the privacy policy. So you can kind of have like a general privacy policy and then include extra specific parts depending on the other countries that you target. So there's different ways to approach it. In terms of what LegalVision can help with, we do Australian privacy advice. LegalVision New Zealand can provide New Zealand advice, and we can also provide guidance on the GDPR as well. Lauren, is there a particular question that you'd like to answer?
So I think there's a couple of questions around who can agree to the SaaS agreement, especially in large companies where there's lots of people, as well as some questions around end users and yours. And so perhaps I'll start off with the question of who can enter into the SaaS agreement. So the general rules of contracts will apply here in terms of who can enter into the contract. And generally what we want is, as a starting point, you might have a director or the company secretary of a company that would sign your agreement with you. But of course, in large companies, that might not always be practical or possible. In Australia, we have laws in the Corporations Act that allows a duly authorised representative to sign an agreement and for that to be legally binding. So long as the person that's signing the agreement in the large organisation is authorised by the business to enter into the contract with you, then that should be okay. Usually what we do also is within the contract, we'll put in some warranties that they're warranting that the person that's entering into the contract has the rights to do so, and that the contract is a valid, legally binding contract. It doesn't hurt as well to do your own due diligence to make sure that you're comfortable with who is signing the agreement. In terms of end users and having your employees use an employee of a larger business also using your platform, for example, you're correct in that sometimes we have a document with end users, so that's an end user license agreement. It's generally a simpler version of the SaaS agreement because we're not putting obligations on end users to make any payment, for example. But what we do from them is some promises from them with regards to how they're going to act on your platform, maybe some promises in regards to personal information and IP and how they're going to use that, and also some limitations on your liability. So if it is the case that you want individuals to sign up to your SaaS agreements contracts with you, we'd get your client and the relevant person in that business to sign up to the SaaS agreement, and then you also have an end user agreement that the authorized users or the end users, employees, for example, could agree to as well. Jacqueline, I've got another global question for you. So if you've got a product that's sold globally, are you still able to have a single version of the contract with the governing law? Or the governing law may not always be Australia or New South Wales. What should we do there?
Yeah, so it is an interesting question and one that obviously comes up a lot. From a legal perspective, if you're an Australian-based company and you have an Australian contract, it's generally best as much as possible to continue using that contract and to continue using the governing law as Australia and your particular state or territory or wherever you want it to be. So the reason for that is that you're the service provider as a SaaS provider, and you're going to be signing multiple contracts with multiple customers. And it's just much easier and more commercially practicable for you to manage those relationships if you're always signing the same or very similar contracts with those customers. And if you know that if any disputes should come up, you're negotiating those disputes or resolving those disputes in a particular jurisdiction, and that your contract's being interpreted based on the laws of a particular jurisdiction. If you do decide to change the jurisdiction of the contract to US law, for example, California, then should you do that, the way that the contract is read is going to change, because the laws of that US state are going to apply instead of the laws of New South Wales, Australia, for example. And once you change that, you might also need to change other provisions of the agreement to reflect the laws in that particular jurisdiction. And so should you do that, it's really prudent that you do get advice in that jurisdiction to understand what you're actually signing your business up to. Some businesses, if they do operate in a jurisdiction such as the US as well, and do a lot of business there, because the US can be quite forthright in saying, no, we want to sign a contract with our jurisdiction. We'll sometimes have lawyers in Australia and sign Australian contracts with companies around the world, but then have a specific US contract as well, is something that we do see come up a lot. The option in terms of if you are going and saying, no, I want it to be New South Wales, Australia, that's what I sign with all of my customers, that's what we provide our SaaS product under. What you can do is have a dispute resolution clause that allows you to start by having a meeting to try and resolve the problem. If that doesn't work, you can have mediation. And if that doesn't work, you can have arbitration, and it can be international arbitration. And the benefit of that is, instead of going to a court in a particular country, where you can go to arbitration, which is more international, you can go to arbitration in an agreed country or location. So it doesn't necessarily have to be Australia or the US, for example. It could be Singapore. And once you do get an award from that, there is a treaty that if countries have signed up to, makes it easier to enforce that in other jurisdictions compared to court orders. So arbitration is generally something we recommend where you are signing agreements with businesses all around the world and not so much just working in Australia. To answer that question, Lauren, it looks like we've got a question here about the differences between an order form and a schedule in an offline contract. You want to talk about that one?
Yeah, okay, I'll run through that. Looks like we've got lots of questions, so we'll try go through them a bit quicker. So in terms of an order form and a schedule, typically your schedule will be your commercial details. So as we said before, the party details, the price, for example, the services that are being provided. That's quite useful in a contract where you're just providing one service and you know you're going to be providing it throughout the whole time of the contract. If you want to enter into a contract with someone where they are ordering some sort of product from you, and then perhaps in a month or two they want to order a different product from you, but the same SaaS agreement applies, that's when we use the order form. And so the order form can be used each time I'm ordering something new from you, and the terms of the SaaS agreement will still apply, and that just makes it, I suppose, a bit easier, and you don't need to negotiate the contract each time. You can just organise what the commercial terms are of that additional thing that I'm ordering. Jacqueline, we've got some questions around cookie policies. Do you want to talk us through how that fits into the SaaS agreement and privacy policy?
Yes, so cookies are interesting because sometimes they are handling what is considered to be personal information or personal data, depending on what laws we're thinking about, and sometimes they're not. And we need to think about privacy laws, but we also need to think about whether there are any cookie-specific laws. So looking at Australia, cookies aren't specifically considered in any legislation, but if they are collecting personal information, then they will fall under the provision of the Privacy Act, if the Privacy Act does apply to you. So in Australia, we would normally address cookies in your privacy policy. However, if we're talking about another jurisdiction like the EU, they do have the GDPR, so if there is any personal data being collected as part of those cookies, but then also they have the e-privacy directive that specifically deals with cookies, including cookies that don't collect identifiable information. So again, it's important to understand which laws you need to be considering, and that's going to influence what you need to do in terms of cookies and whether you have any extra obligations like consent obligations or an obligation to have a separate cookie policy. Lauren, did you want to talk about, there's a question here about if a customer wants to prepay for a SaaS,
Yes.
how that can be approached contractually?
Sure. So the payments are a good topic to talk about. There's a lot we can talk about here. Obviously, when you're providing your product, you want to get paid. That's why you're providing it. And there's different ways that that can happen. You might want your customers to pay you in advance, or you might have situations where they're paying you in arrears. And so when they need to pay you in advance, for example, if they're paying you 12 months in advance, we can draft it in a way whereby the license won't commence until they've made payment to you. This is a great position for you to be in, because then you know that you've received the funds, as opposed to people paying in arrears. Obviously, not all businesses operate that way, and they might not be agreeable to that. Other things that we see clients do is set up direct debit. And so that way it's automatically debited from your customer's account every month, or however often you've agreed with them. That can be quite useful in that I suppose it's less likely for them to forget to pay you. Of course, the other option is invoices, which might happen on a monthly basis or annual basis. In terms of pricing, we often see that different businesses will offer incentives for people to pay upfront or to pay on a longer contract as opposed to shorter contracts, and so you might offer a discount. The other things that we often see in payment clauses are basically repercussions of what happens if a customer doesn't pay. So you might want to charge them interest, or you might want the right to be able to get a debt collector to help you to collect those funds, and of course suspend the services until they have paid those funds. Jacqueline, was there another question you wanted to run through?
Do we have time for any more questions, or should we?
Perhaps this can be the last one.
The last one? Okay. There's a question here about commercializing customer data and whether it's best to do this in an offline agreement. So whether your SaaS agreement is online T's and C's or an offline hard copy agreement, we should always be addressing customer data. So you're always going to need some form of license and right to be able to use that customer data. And we're always going to want to set out what those uses are going to be. If you want to be able to use it to create analytics, so to put it into a de-identified format and reuse it for your own purposes, including commercializing it by reselling it, for example, then we just need to say that in the contract. If you're not using personal data, so once you've de-identified it, there's no personal data involved in the data any longer, then it's not really a huge issue. It's just a matter of contractually making sure that it has been covered. If you are intending to use personal data in a commercial way, then that's a completely different issue, and we would need to think about what privacy laws apply and whether you're permitted to do that. So do you need consent, or do you need to set a reasonable expectation otherwise, and make sure that it's related to the primary purpose that you collected it for? So we would need to think through how that would work. But where you're just turning it into analytical data that doesn't identify anyone, then typically we can set up an expectation that that will be done. And once it's de-identified, as long as you can't re-identify it, you shouldn't have any further issues in respect of privacy.
Okay, I think that brings us to the end of today's webinar. Thank you so much for joining us today. It's always good fun to run through these questions and see what people want to know. The last thing I'd like to do is run through a special offer we've got for you today as an attendee of the webinar. So a special offer is a strategy session with some of the my colleagues at LegalVision, or perhaps myself, to discuss what your SaaS agreement needs are and any of your other legal needs and how we can support you. And attendees can also receive a free month of access to our LV Connect Pro membership. LV Connect Pro is our membership. Basically, it's an all-inclusive membership. You can pay a weekly fee and it gives you unlimited access to contract drafting, contract reviews, and consultations with our lawyers. So if you've got more questions, you can just book in a consult with our lawyers and then we'll give you a call and have a chat to you about that. So if you'd like to book in a strategy session with us to have a bit more of a chat about what your legal needs are, answer any of your questions, and then set you up for a free month of access to LV Connect Pro, and then you can click yes in the survey that will appear after the webinar, leave your contact information, and we'll be in touch to set up that initial meeting with you. So thank you.
Perfect. Thank you so much. Lovely to be here. Bye.
Bye.